I'm grateful for the privilege of appearing in this court once again and consider myself deeply honored at this opportunity to present India's case before you in this unfortunate matter relating to the life of an innocent Indian. This case, Honorable Mr. President and members of the court, arises out of an application filed by India under Article 40, paragraph 1 of the statute of the court, and Article 38 of the rules, read along with Article 1 of the optional protocol concerning the compulsory settlement of disputes done at Vienna on 24th April 1963. The basis for the application on which India is pursuing the reliefs which are articulated in its memorial is an egregious violation of the Vienna Convention on Consular Relations 1963, which I shall be referring to as the Vienna Convention. The case is simple. Shorn of the irrelevancies sought to be injected, there are two broad issues that arise in this case. The first issue relates to the construction of the Vienna Convention, particularly Article 36 of the Convention and its application to the facts of the case. On this, the admitted position being that consular access was not granted. If Pakistan's strange defense of exclusion of such cases is not accepted, then it has to be found that Pakistan is an egregious breach of the Vienna Convention. The second relevant issue then is the relief to be granted in this case. The Charzo factory principle of restitutio in integrum is now the settled basis for relief. The only issue is whether past precedents of this court relating to a violation of the Vienna Convention, which granted relief by way of review and reconsideration, have laid down law an inflexible rule which has to be followed in all situations. India says that the court would have to decide whether the rule can apply to military courts like the Pakistan Military Court, and whether courts that do not rise to the standards of due process can be the repository of faith of the kind this court reposed in the American criminal justice system, in Avena and Legrand. Finding itself bereft of any substantive defense, Pakistan has raised a host of issues which do not have any real relevance to these proceedings. On the issue of construction, Pakistan seeks to run one and only one defense. For diverse reasons, it suggests that despite the plain language of Article 36, it stands jettisoned when the host state alleges espionage and national security. Its submissions run counter even to the authorities it chooses to cite. Pakistan runs unmeritorious defenses under the chapeau of abuse of process, abuse of rights, of extirpe causa. It misstates the law, it misreads commentaries, it relies on material that is not recognized as having any precedential value. And finally, having failed in its propaganda against India, as a feeble attempt to counter global criticism of its role in cross-border terrorism, Pakistan seeks to raise issues such as India's refusal to allow it to indulge in a freewheeling inquiry into high functionaries without even disclosing the fundamental elements of the alleged offenses that are to be investigated and of passports that it allegedly has seized. It is India's case that none of these issues call for resolution and decision by this court.